Hey, it's your girl, your favorite paralegal, aka Cassandra Lynn, and welcome to Legal Doc Talk 24/7. So we have a Diddy update. Let's hop right on into it. If you guys have watched the previous video or previous update that I did on Sean Combs, this was in regards to his motion for bail, and he's pretty much putting up $50 million along with anything that his family could put forth, as well as some strict conditions of him being released if he is, like the 24/7 surveillance, the not speaking with other people other than the approved family member, so on and so forth. So a lot of fluff that he put into this new bail package that he is going to present to the court next week, or this coming week, I should say. But it has been revealed in what you see on our screen, the government's opposition to the defendant's renewed motion for bail. They're like, he's pulling the same old from Fort Worth to Plano, and it's ridiculous. I was like, you gotta be kidding me. And my thought process when I was reading the language regarding him not being able to speak with anybody other than his family members, I was like, what is to say that he won't be like, call somebody on three-way? Or you see what I'm saying? So if I had that thought process with him outside of jail, I can only imagine what he's doing in jail. You see what I'm saying? But let's hop into why the government actually filed this opposition. So the table of about to say comments, contents pretty much says it all. I know that you guys can't really see it, but I'm going to read to it if you can read it between the lines, because I have my watermark on and I have to have it for purposes of other people using content. But anywho's, so the court should reject the defendant's attempt to reopen the bail hearing based on the same information he presented to Judge Carter. So this man has, how can I say this? In the third motion for bail, he did switch up a few things, but it was similar to the other two motion for bails that were denied. Why does the government feel that they should reject it? Because they said that the defendant's rehashing of the same personal attacks he's made against victim one before Judge Carter is not new information. Two, the court should reject the defendant's request to reopen the bail hearing because the defendant disagrees with the government use of the term victim. That they are victims. What else are you going to call them? They're victims. And number three, the defendant's contacts with witnesses demonstrates the threat he poses to the integrity of these proceedings. And that is going to be the key right there of why he is probably going to stay in jail, probably get his phones restricted and whatever, not having access to a laptop, the whole 9 yards, because you are in jail still not complying. Other sections, it says the defendant cannot rely on Section 3142I for his release. The defendant poses a serious risk of obstruction, danger, and flight. And their reasonings to back this up, it says that the defendant has continued his efforts to obstruct justice. The defendant is a danger to others, and the defendant continues to pose a flight risk. And then the last argument is that the defendant's new proposed bail package is insufficient. All right, so we have all the cases that they are incorporating. All right, preliminary statement. The government respectfully submits its opposition to defendant Sean Combs' renewed motion for bail. The defendant's motion should be denied, as two judges have already concluded, based on the evidence in the record, the defendant poses serious risk of danger and obstruction of these proceedings. In seeking a new hearing, the defendant rehashes the same arguments rejected by those two judges with claims of new evidence. And that's exactly what they said in that third motion for bail. They saying new evidence. What's the new evidence? But the defendant offers nothing new and material justifying a third bail hearing. In fact, the only truly new relevant evidence shows that the defendant has continued to engage in a relentless course of obstruction conduct designed to subvert the integrity of these proceedings. As described in detail below, while attempting to evade law enforcement monitoring, the defendant has, among other things, orchestrated social media campaigns that are, in his own words, aimed at tainting the jury pool, made efforts to publicly leak material he views as helpful to his case, and contacted witnesses through third parties. For these reasons, the court should deny the defendants a new bail hearing. To the extent that the court decides to reopen a bail hearing, however, the defendant's application for bail still must fail under the Bail Reform Act. His motion ignores the significant evidence presented by the by the government at the prior hearings, showing that the defendant is a violent serial abuser who uses his vast wealth and position in the entertainment industry to conceal his illegal conduct and prevent victims of and witnesses to his abuse from coming forward. In light of well documented danger posted by the defendant, the updated proposed conditions of release are woefully insufficient to assure the safety of the community and the integrity of these proceedings. Indeed, the defendant's continued obstructive conduct confirms the conclusion reached by two other courts: no set of conditions can meet that task. The defendant's request for temporary release pursuant to Title 18 of the United States Code, Section 3142I, should similarly be rejected. The defendant's confinement at the Metropolitan Detention Center, Brooklyn, which is known as MDC, affords him more than adequate opportunity to prepare for trial, and his convenience does not provide a basis to reevaluate the danger to the community and the threat to the integrity of the proceedings that the defendant release poses. Child. So while Diddy stating in his motion for bail that this facility has constant lockdowns and he can't, prepare for trial, he can't review discovery, and he hasn't got his laptop, the government is saying, "Look, bro, where you're at is okay. You can do whatever you need to do at the MDC. You don't need to be out in the community because you pose a threat." All right, we don't need to go into the background because we already know this. Let's see. Their argument, it says, under the Bail Reform Act, the district court has discretion to reopen a bail hearing if information comes to light that is both new and material to the detention question. Specifically, a bail determination may be reopened before trial if the judicial officer finds that information exists that was not known to the movant at the time of the hearing and that has a material bearing on the issue whether there are conditions of release that will reasonably assure the appearance of such person as required and the safety of any other person and the community. However, a bail hearing should not be reopened on the basis of information that was available to the defendant at the time of the hearing. In courts in the Second Circuit have found that new and material information for Section 3142F to B purposes consist of something other than a defendant's own evaluation of his character or the strength of a case against him, truly changed circumstances, something unexpected, or a significant event. Moreover, the because the Bail Reform Act states only that a hearing may be reopened if new and material information is presented, it leaves the decision to reopen the hearing to a sound discretion of the distinct court. Therefore, even if a defendant's argument for reopening the hearing met the standard, which they do not, this court may still decide in its discretion not to reopen the hearing. One thing that a lot of people don't realize is that the judicial department, the judges interpret the law. They take the law and they apply it to the situation. So they're going to see how everything in his motion package, how that they're going to interpret it, if that makes sense. It's like, okay, here is the law. Does your how can I say this? Not the language, but does your argument correlate with what's in law? He's trying so hard to say, okay, because of this. So in his motion package, he said that they have new evidence, right? New information. But the state is saying there, well, not the state, the government is saying there is no new information. This is information that has been presented in the previous two motion for bail packages. There are no new information other than them finding out that he is still trying to intimidate the jury and witnesses in this case, in the victims. That's the only new information that has become available. Wow, ain't it? But at the end of the day, it's still going to be up to the court to see if he is, if he will be released. He could be released and they might impose stricter conditions. We don't know. We just have to see when the bail hearing comes. But me, in my head, I don't think he go get out. I think they, the job of the attorneys, whoever they are representing, have to fight really, really hard for their client. So they're going to put any and everything in that petition or pleading to persuade the judge. And by Diddy doing that third package, that motion for bail package, and adding all of that extra stuff, like, I'll do 24/7 surveillance, but you don't want it to be a government official. You want it to be like a security company. That's, like I said, you could get paid. People bribery, okay? Bribery. And you're saying I'm not going to consult other than people in my family, my kids, and my mom, and my baby mama. Who's to say you're not going to ask them to call somebody on your behalf? And what you've been doing, apparently, because the government found out about it. Like, you're on these jail calls, you didn't think they were listening. And you can't even do three-way. If you try to do three-way, I believe they will, what, the call a drop or something like that. There's certain things that you cannot do. And he tried to do. All right, going on, it says Section 3142I provides that a court may permit the temporary release of a person in the custody of a United States Marshal or another appropriate person to the extent that the judicial officer determines such release to be necessary for preparation of the person's defense or for another compelling reason. Um, this provision has been used sparingly to permit a defendant's release where, for example, he is suffering from a terminal illness or a serious injury. In considering whether release is necessary for preparation of a person's defense, because that is the argument that they're trying to make. The bail Oh, I'm sorry. The Bail Reform Act simply requires that a defendant in custody be afforded reasonable opportunity for private consultation with counsel. So they were trying to say in the motion for bail, because of the conditions at the jail, they keep having lockdowns and, blase, 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 that Diddy could not adequately prepare. If he did, they can make arrangements. If you say I don't see the correctional facility not abiding by the rules, like, because that opens them up for, legal actions. So why aren't y'all able to adequately, he doesn't need a laptop, that's what I'm saying. You just gonna have to put in extra hours. Ain't that what he's paying you for? You call down to the jail and say, hey, I need this time to this time with my client. You bring your laptop and you sit there and you monitor him while a guard is in the room to review the whatchamacallit. You set up certain days. We meet 3 times a day, or maybe we meet 5 times a week. You could do this. They just choose not to do it. But once again, they got to fight for their client, right? It says pretrial detention will always interfere with the preparation of trial to some extent, but the Bail Reform Act clearly contemplates this problem and allows for detention provided that the defendant is afforded reasonable opportunity for private consultation with counsel. The defendant has the burden of showing temporary release is necessary for the preparation of the person's defense, in which it was denied in the first 2 motions. I don't see a difference in this third motion. My dogs are going crazy. If y'all hear them in the background, I do apologize. And so the discussion is the court should reject the defendant's attempt to reopen the bail hearing based on the same information that he presented to Judge Carter. So it says the defendant's motion to reopen the bail hearing should be denied for the simple reason that he has not presented any information that was not known to him at the time of the bail hearing before Judge Carter. As set forth below, the defendant asserts that the court should consider new information relating to the defendant's relationship with victim one and his communications with various witnesses as a basis to reopen the bail hearing. But these allegedly new facts are the very same arguments made by defense counsel and rejected by the district court previously. Dressed up with recently produced discovery. Because those facts were known to the defendant before any discovery production, and because the defendant relied upon them in his prior hearing, he cannot recycle them here to revisit the sound determination made by Judge Carter that the defendant is a danger and risk to obstruction and must be detained. So, reasoning. The defendant's rehashing of the same personal attacks he made against victim one before Judge Carter is not new information. All right, hold on. I'm going to put a pause here because my dog's about to get to arguing. Who my dogs don't like each other. All right. So we have, let's see, the defendant claims that the communications between defendant and victim one, which was recently produced in discovery as part of the defendant's electronic devices and accounts, constitutes new material. The defendant claims that the recently produced text messages revealed a loving, at times toxic, long term relationship between two adults who decided mutually to break up. This claim is nothing new. Defense counsel made these exact points and even referred to the text messages and communications at the September 17, 2004 hearing, after nothing that he had looked through more text messages and emails than he cared to. Defense counsel observed, and I'm going to read this. This is a 10-year relationship. This is a sex trafficking is a 10-year relationship. These two people were in love. That that will be made abundantly clear by the way they speak to each other, by the way other witnesses describe their time together, and by the circumstances of how they broke up. They were in love, but Mr. Combs wasn't always faithful. At the end of the day, there was mutual philandering, and victim number one ended up marrying the trainer that Mr. Combs got for her and had two children. That signaled the end of the relationship. There is nothing new about the content of the text messages between the defendant and victim one that was not known to the defendant at the time of the initial hearing, which is correct. Furthermore, presenting recently produced text messages, the defendant cherry picks to paint a misleading picture, ignoring numerous other messages in the record between the defendant and victim one, documenting the defendant's physical abuse of victim one and his threats to expose recording of freak-offs. September 18th transcript reads at 6, text message reading, "You know what sick and disgusting ish I was reminded of the other day? You forcing me to blank, or you were going to leak some freak off ish." At 10, it says, "I have a black eye and a fat lip. You are sick for thinking it's okay to do what you've done." Lord. "I still have crazy bruising." At 16 and 17, it states that I have bleeding cuts. Oh, no, no, no. Hold on. "I turn my head for a second and you get effed up and you drag me down the hall by my hair. I have bleeding cuts. You hit me in the head 2 times. When you got me effed up the wrong way, you always want me to show that you have the power and you knock me around. I'm not a rag doll. I'm someone's child." Moreover, despite attaching lengthy text messages between the defendant and victim one on various dates between August and November 2018, the defendant omits messages produced in the same thread about defendant's violence. The defendant also rehashes his attacks on victims one motives and bringing a civil lawsuit against defendant, suggesting that victim one's allegation against the defendant were merely attempts to obtain a financial windfall from Mr. Combs. So we already know this is in regards to Miss Cassandra Ventura. Um, let's see. So that's not new information. He's trying to use that, and that's not new information as far as the text messages and stuff like that. That's not new. So you can't use that because they already denied it twice in the two motions that you already tried to get approved, and they were denied. The court should reject the defendant's request to reopen the bail because the defendant disagrees with the government's use of the term victim. Uh, that's crazy. The government did no such thing. The defendant's primary point of contention appears to be the government's characterization of this individual as a victim. In quibbling about how to label victim two, an individual to whom the defendant continues to pay a significant an individual to whom the defendant continues to pay a significant monthly sum, the defendant does not present any new information or grapple with the actual evidence. So what? Hold on, let me get to two. Bank records show the defendant's payments to victim two as recently as mid-September 2024. The government has requested and is awaiting updated financial statements through the present. Babe, you're trying to pay people to stay quiet, but the victim is still, baby, I guess I'll still be trying to get that money too. But that's wild. That is wild. Whether or not the defendant agrees with the characterization of victim two as victim for purposes of his criminal case, the communications highlighted by the government indicate that the defendant used financial coercion to attempt to feed victim two a narrative that was consistent with his defense theory, a theory at odds with contemporaneous text messages sent by victim two to the defendant and others. Um, and the September 18th transcript reads that the defendant just threatened me about my sex tapes where I am heavily drugged and doing things he asked of me. 21 is describing victims two's trauma in light of the defendant's continual financial support of victim two. It is not the government, but rather the defendant that is misleading the courts. Okay, so I'm assuming I'm about to call him Honeycomb. Sean Combs is not considering this person a victim for the simple fact that they are still accepting financial support from Combs. But if this victim has been victimized, then they are a victim because they still talking about the trauma. You mentioned that you threatened to leak out sex tapes. They are a victim. The third reason that the government said that the court should reject the third motion is that he continues to contact witnesses um, in which he poses a threat to the integrity of the litigation proceedings. For witness one, in which we already know that's Cassie, the defendant attempts to spin his contacts with witnesses, including witnesses served with grand jury subpoenas as evidence of rebuting the government's proof of obstruction failed in their entirety. For example, the defendant claims that the government misled the court and concealed the actual content of the communication between defendant and a witness who was served a grand jury subpoena in June of 2024, which is witness number one. Oh, no, it's not. Why did I say Cassie? She's victim number one. This is witness. All right, my bad. Sorry. Um, it says, as an initial matter, the nature of substance of the defendant's communication with witness one was known to the defendant at the time of the initial hearing. But more importantly, these contacts, including the fact that the defendant evidently deleted the messages from his phone, confirm the government's pre-offer at the initial hearing and refute statements made by defense counsel. I've always said this. I don't care if you delete it several times, it's somewhere and it will be obtained. And they did that. Specifically, phone records show that between the end of 2022 and January 2024, witness one occasionally contacted the defendant by phone without any response from the defendant. That changed in June of 2024. Witness one was served with a grand jury subpoena on June 19, 2024, and after contacting the government, was appointed counsel on June 25th, 2024. Beginning on June 26, only after witness one had been served with a grand jury subpoena and had counsel, the defendant initiated contact with witness one. So it wasn't until Diddy found out that witness one actually had an attorney that he decided that he wanted to contact witness one, in which the defendant attempted to obscure by initially calling witness one's wife and later communicating with witness one over a VoIP service, including by text and a call lasting over several minutes. The following day, phone records indicate that witness one spoke with counsel for the defendant. Even though witness one was represented by counsel, he and the defendant continued to directly exchange text messages, and defense counsel also spoke directly with witness one again on July 8, 2024. Following witness one's testimony in the grand jury on July 25th, 2024, the defendant called and texted witness again. Once you have attorneys, there's no reason for either party to be communicating with each other. The attorneys now have to communicate on your behalf. So, I mean, it's not like they're going to tell on themselves, but it's very interesting that I don't know. It's interesting. It's just really, really interesting. Like you know what's going on. You see everything all over the news is what's going on. And you still thought it was okay, excuse me, to talk to the defendant after he been ignoring you. Like he was ignoring you, and then you got counsel, and then you were served, and then you got counsel. Now all of a sudden he wants to talk to you. What other motive do you think this man had other than to brainwash you or bribe you? Defendant repeated contact with witness 1 despite his apparent knowledge that witness 1 was represented by counsel and had received a grand jury subpoena, undermines defense counsel previous denials of defendant's interference in the government's grand jury investigation, and shows that counsel cannot stop the defendant from contacting grand jury witnesses. And that's what it is. So that's why this man needs to stay in jail, uh and revoke his phone privileges. I don't feel bad. I really don't. The only time that you're able to talk to anybody is your jailmates, or and see, here's the thing with that, because now you're in jail and you're having other jailmates, you're like, hey, let me use this, or hey, call this person on three-way, da 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 da. You gonna mess around and get their stuff revoked. That's crazy. This concern is amplified by evidence indicating that the defendant appears to have deleted his messages with witness 1, although the phone records confirm that the defendant, using a particular phone number in 2024 through August 2024, where there were no such messages recovered from the defendant's cell phone associated with that phone number. As far as witness 2, Sean Combs contacted them in September of 2024, and this individual is also represented by counsel. And it says, who wanted to make a public statement. Were not in any way obstructive because defendant and witness 2 were previously in a frequent contact. However, the contact between defendant and witness 2, who were bandmates, stopped in March of 2024. And from the timeline and the context of defendant's contact with witness 2, it is clear that the defendant reinitiated contact with witness 2 in September of 2024. His purpose was to ensure that witness 2 was on his side and to pressure witness 2 to make a public statement denying allegations of violence by defendant. Is that Mace? He said a bandmate. I'm sorry, y'all. I'm on my phone looking. Cause I'm like bandmate. Who else did he Oh wait. Mm, it was a trio. Oh. Don, Richard, and Kalina Harper? Is that who they're talking about? Well, we'll see. If y'all know, please leave it in the comments. Um, the defendant reached out to witness 2 on September 11, 2024, and sent her a copy. Now, wasn't this man in jail? So he reached out to her and sent her a copy of the lawsuit. Oh wait, or did he go September? I can't remember. Hold up. And I'm Googling again. When was Diddy arrested? Um September 18th or 16th? Was Yep, he was arrested on the 16th. All right, so before he got arrested, so defendant reached out to witness 2 on September 11th, and sent her a copy of the lawsuit against the defendant in which witness two's name was mentioned several times. The defendant then called witness 2 and they spoke for nearly 6 minutes. After reading the lawsuit, witness 2 called the defendant back at his request and they spoke for over 4 minutes. Evidently, the defendant and witness 2 discussed witness 2 drafting a statement as immediately after the call. The defendant told witness 2 in a text message. Wow. The defendant then asked witness 2 for her attorney's name. Bro, I'm thinking some of these attorneys are probably in on it. especially when it comes to money. From September 11th, 2024 through September 15th, and that was the day before he got arrested, the defendant and witness two exchanged multiple texts and had multiple calls. At least 128 phone contacts in total. Throughout these phone contacts, the defendant repeatedly asked witness two when she planned to post her statement. Oh man, now I gotta go back and do this. I gotta do some research. Witness 2 ultimately made a statement about the lawsuit via Instagram post on September 13th, 2024. Then, after the defendant was in custody, BOP investigators recovered the following notes from the defendant's cell. During a pre planned nationwide sweep of BOP facilities. So let's see, footnote 4. With respect to materials received from BOP, that's the Bureau of why did I just go blank? Bureau of Prisons that included possibly privileged materials such as the notes recovered from the defendant's cell. The prosecution team only assessed those materials after they have been reviewed by the filter team, including the government for potential privileged search warrant materials. That's crazy. Um, Example E. The strong influence to be drawn from the defendant's communications with witness 2 and his personal notes is that the defendant paid witness 2 after she posted her statement. Who posted a statement via Instagram for Sean Combs?
According to the New York Times, prosecutors said that investigators from the Federal Bureau of Prisons found notes in Mr. Combs' cell related to Ms. Harper. The contents of the notes were redacted, but prosecutors wrote that the strong inference was that Mr. Combs paid Ms. Harper after she posted her statement to Instagram.
My. Y'all heard it. From the timeline, the context of the communications between the defendant and witness 2, the defendant clear goal was for witness 2 to draft and post a statement. Even after the defendant knew that witness 2 had counsel, he continued to reach out to her directly, a fact and clearly concerned Judge Carter, and rightfully so. That the defendant had multiple phone contacts with witness 2 up to and including March 2024 changes nothing about the damning timeline and consent of the content of his calls in September of 2024. These communications are another example of the defendant using manipulation, influence, and power to persuade witnesses to support him. Leave this man in jail. Leave him in jail. The defendant cannot rely on 3142, and I believe that is the is that the bell? Nope, that's not it. Let me see. I'm trying to read. I don't want to read all of this because it's 30 pages. Alternatively, the defendant moves for a pretrial release under Title 18 United States Code, claiming that the defendant cannot adequately prepare his defense at MDC. The law does not support the defendant's release under this provision either, as the defendant has not amply been afforded reasonable opportunity for private consultation with counsel. First, MDC has provided the defendant with more than reasonable accommodations to meet with counsel. The defendant is permitted to look. Yeah, I knew it. I knew it. I knew it. I knew it. I gotta read this part. First, the MDC has provided the defendant with more than reasonable accommodations to meet with counsel. The defendant is permitted to meet with counsel 7 days a week and regularly has access to a separate conference room off the common area of his unit. In fact, records indicate that the defendant has met the defense counsel most days since he has been in custody. Records also indicate that the defendant frequently communicates with his attorneys by telephone and written communication, including, as explained below, through unauthorized means. But even if the defendant were only using authorized channels of communications, the MDC's procedures do not infringe on the defendant's constitutional right to effective counsel or to participate in his defense. Boy, they was making it seem like this man was living under harsh conditions, and he was not, able to prepare for trial. And they have, what I say in the beginning. What did I say? He should be, it's the attorneys or whoever his representing him can call down there and say, hey, this is how many times we need to meet with him for how long. So I knew this because that was a bunch of baloney that they tried to feed. Like people wasn't going to sit there and find out. I am so confused. I am so confused. Boy, you are this they're going to look at this and be like, we're going to deny this one too. I have a feeling. Second, defense counsel proposal that the defendant must be released in order to prepare his defense is inconsistent with the Bail Reform Act, which contemplates that court will weigh dangerousness and risk of flight against a defendant's opportunity to prepare for trial. In this case, the significant danger that the defendant posed weighed against the opportunities the MDC has provided the defendant to meet privately with his attorneys clearly counsels in favor of the defendant's continuing detention. He is a flight risk. No. Leave him where he at. Leave him where he at. They tried to use the discovery, saying that it was a whole bunch of discovery that he has to go through. Third, voluminous discovery alone is not a basis for release under either the Bail Reform Act or the Sixth Amendment. The defendant does not point to any case law suggesting that discovery of the kind produced in this case requires the defendant's release under Title 18 of the United States Code, Section 3142I, nor can he. They reference Dupree, which states that while this fraud case may in fact be complicated and require a defendant to review hundreds, if not thousands, of documents or meet with his lawyers for dozens of hours, for that fact standalone simply does not justify a defendant's release. Indeed, accepting such an agreement would mean that the more complicated the crime, the more likely a defendant should be released prior to trial. This is clearly an absurd result. The Bail Reform Act does not mandate defendant's release, even if review of discovery would be more convenient outside of MDC home and well MDC. And if you have not seen my review going over the motion for bail package, the third one, please go ahead and do so so you can understand the way that his team was making it seem. And it's not even making it seem, we know that there are terabytes of discovery that the government has gone through, but what they're saying is that is not a basis as to why he should be released. Okay? As you can see here, and the government has pointed this out, they are able to go up there 7 days a week. They have a special conference room that he can be in. So he just wants to be in the comfort of his own home so nobody can monitor what he does. Yes, he said he wants 24-hour surveillance, but not with no government officials. No. He wants to be able to pay for his own security surveillance team. That's not going to happen, my boy. But they're trying to use, oh my God, it's an overwhelmingly amount of discovery, and he doesn't have the proper laptop. And, we submitted a laptop and they haven't reviewed it yet, so on and so. Y'all, that is not even a basis. It's not even a factor in when the judge looks at this and he takes into consideration certain factors. That's not even one of them. Let's see where I left off at. Da, 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 da. Moreover, the aggressive trial schedule was specifically requested by the defendant. He asked for a speedy trial, right? hmm If he needs more time to review discovery, he can request an adjournment of the trial date. Booyah! Booyah! He asked for a speedy trial, right? You asked for a speedy trial. So if you need more time with your counsel at MDC to review the discovery, why not push back the trial date? Because I've said it. I'm looking at the amount of discovery. There's no possible way that they are going to make have trial on May 5th. It's absolutely no way. So I'm thinking the government should just keep doing what they doing, because by the time that comes out, he's gonna be like, well, if they use the excuse that they still need to review discovery. But in the event that they do, because I think they might want to review all discovery to see, what's against him. Um, they need to push back that trial date, because May 5th ain't it. Finally, the defendant's complaints about the conditions at MDC come to oh, hold on, let me reread that. Finally, the defendant's complaints about conditions at the MDC come as a surprise to the government, given the contrary public statements made by the defense counsel and statements made by the defendant in monitored cells. Oh, I'm sorry, monitored calls. So let's see what footnote 6 says. It says, Sean Diddy Combs' attorney says food probably the roughest part of Mogul's life in prison. He said the food. He didn't say anything about the conditions. He said the food. Now you think that somebody who is stating that the conditions at this facility is horrible, the only thing you got to say is about the food? Make that make sense. Additionally, defense counsel has made no attempt to confer with the government about their concerns. Nonetheless, the government stands ready to engage with defense counsel of the issues if needed. So, if there's anything that is out of place at MDC, please let the government know, because that's what they do. They oversee these things. Three, he poses as a serious risk of obstruction, danger, and flight. Let's see. It says for the reasons described above, defendant has not met his burden of demonstrating. Because remember, they always have the burden of proof. So you're putting out this motion, so you got to prove these things. So he has not met his burden of demonstrating that he is entitled to another hearing. Accordingly, the court need not make a determination regarding defendant's risk of flight or dangerousness. However, even if the court were to analyze the factors under Title 18 of the United States Code, Section 3142G, again, the court should continue the defendant's pretrial detention, because no condition or combination of conditions can assure the defendant's appearance and the safety of the community, nor can conditions prevent the defendant's continued obstructive efforts. So that just simply means that, because under the Title 18, under that 3142, if he is released, there's a promise that has to be made that he is going to appear back to court. Who's to say this man is not going to flee like Russell Simmons? Another part of that is you being able to have access to other people that can contact other people, such as witnesses and victims, right? Who's going to be able to monitor that? You pose as a threat. And if you are sitting here trying to bribe, trying to intimidate, that is obstructing the litigation process. Um, it states here that he has continued efforts of obstructing justice. This man's motion has been denied twice. Let me see. Since the defendant has been detained at MDC, he has continued to try to evade law enforcement monitoring, corruptly influence witness testimony, and further attack the integrity of these proceedings. Specifically, while in custody at the MDC, the defendant has repeatedly communicated with others in ways that violates the BOP, that's the Bureau of Prisons rules, and are designed to evade BOP and law enforcement monitoring, including, as described below, using PAC numbers belonging to other inmates to make calls, using three-way calls to contact other individuals, including individuals who are not on his approved contact list, and using an unauthorized third party communication system to send messages to numerous individuals, including unauthorized contacts. Because remember, in his motion, the authorized contacts, I believe, was his mama, his baby mama, and his children and counsel, but nobody else outside of that. But records show otherwise. This is crazy. He has used, boy, look at, the government has reviewed dozens of recordings of BOP jail calls in which the defendant uses telephone accounts of at least 8 other inmates, which is against BOP regulations. My boy. Payment process apps, BOP commissary account deposits. So it's like, you give me your telephone calls, I'll give you some food. Three-way calling. You can't do that. Non-authorized messaging services. Let's see. So he used a third-party messaging service called Contact Me ASAP. And he has, first, the defendant's BOP contact list includes a particular email address assigned to the defendant's son, which does not appear to be on an account owned by the defendant's son, but instead appears to be an email address connected to Contact Me ASAP. Boy, he is trying to get out of this, y'all. Oh my God, guilty, 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 guilty. You doing everything in your power to sabotage this case that you are effing up. This screams guilty all over. It screams. I hope the government builds a solidified case. They have to. This is not a black and white thing. This is, you are guilty of everything that they are alleging in the indictment, and he's trying to get away from it. If he had to flee, guess where he going? He going right up there with Russell Simmons. That's what he's trying to do. He's trying his dark, because as soon, if they release this man, if they release this man, if they release this man, he is gone. And he gonna be living his best life with his kids somewhere other than the United States of America. Oh, no, I'm trying to read because I seen birthday. After the court entered the order, the defendant enlisted family members to plan and execute a social media campaign around the defendant's birthday with the intention of influencing the potential jury in his criminal proceeding. At the defendant's carefully curated direction, the defendant's children posted a video in respective social media accounts showing the defendant's children gathered to celebrate the defendant's birthday. I seen that. I was like, "Oh, that's so cute," but we all get it. Cause after they did that, they probably went their separate ways. Like, I don't fuck with you like that. No, that was for a show. Cause I've never seen that. Like, I, I mean, I don't follow Diddy, so I don't know. But I've never seen where they've done that every single year. Mm-hmm. Mm-hmm. The defendant does not stop here. During other calls, the defendant makes clear intention to anonymously publish information that he think will help his defense in his case. They redacted a lot of stuff, so we can't really see. The defendant's efforts to obstruct the integrity of this proceeding also includes relentless efforts to contact potential witnesses, including victims of his abuse, who could provide powerful testimony against him. For example, on October 4th, 2024, in a call involving the defendant and one of his adult sons, the defendant says, oh man, darn it. Gosh, giggly oogly. And those documents are sealed, so I can't even see them. Provides the clear inference that the defendant's goal is to blackmail victims and witnesses into either into silence or providing testimony helpful to his defense. And he's definitely dangerous to. I mean, after all of this, we already know he's dangerous to others. We've seen what he did. We've seen what he did in that hotel video with Cassie. We've heard about what he has done. And in supporting evidence, they looked at his long history of abuse. So they have witness testimony, they have communication, they have photos, videos, police reports, any other material that demonstrates his abuse. The government has. And we know he poses as a flight risk. I don't even need to go. So, in a nutshell, this new proposed bail package is insufficient. He poses a risk of obstruction, danger to the community, and a risk of non-appearance because he gonna leave. And everything that he listed in his bail package was already stated in the other two. He just, like I said, he fluffed it up. He's like, okay, why not a $50 million bail? Why not me just being monitored 24/7 and I'll foot the bill on the security? Or why not limit my calls only to family members that you guys approve? Yeah, bro. I'm not, yeah, I'm not seeing it. I'm not. I think this is going to be denied. And what they did was they went ahead and attached the other correspondence that was submitted to the court back on September 17th and 18th. And they actually have, and this is just kind of breaking down the abuse, other violence, the firearms. Look at this. Look at this. How he bribed witnesses and obstructed justice. So this is not anything new that has been submitted to the court. This is all the same. This is all the same information. So he's putting out these motions for bail. They were denied by the lower courts, sent up to a higher court. They denied it. You trying again, asking for a rehearing. There's nothing new that Diddy is presenting. What he's doing is he is digging a hole deeper and deeper and deeper. And everybody in this world can see that. It's very evident. You are still having contact with people that you should not be having contact with, whether it's the witnesses or the victims. um there was what a part in there where it was talking about, well, let me talk to your counsel. So who's to say that some of these counsels, it's, oh my gosh, it's an overwhelmingly amount of people that are involved in this. There's an overwhelmingly amount of uh discovery, evidence, all of this stuff. But just to kind of speak on this third bail hearing that you requested, there's nothing new under the sun. You're still making the same argument but fluffing up to try to see if the judge will have a different outcome. The actions that you are taking, and you not thinking that the government is actually paying attention to your phone calls, to this and that, how blinded are you? Or do you think that you just have this money, this power, and this status that you over trump everybody? I think that's probably what it is. He thinks that he is who he is, and he's invisible to people finding out him doing anything. Like how yeah, I'm baffled. I honestly, so my question that I want to pose to you guys is, do you think that he is going to be granted this third bail hearing? And well, it's not granted the bail hearing, but granted to be released. Do you think that he's going to be released? If you do, list in the comments your reasoning as to why you believe he's going to be released. Because on my end, based off of the Reform Act, Title 18, 3142, Section 3142 of the United States Code, he has not presented any new information, no new material. All of this is old. He is contacting witnesses and victims. He's making up stories about how the facility is messed up and he cannot adequately prepare for trial, due to the overly amount of discovery that he has. But yet he still meets with counsel 7 days a week. They have a private conference room. The list goes on. So everything that he says, the government comes back and shoots it down. So I don't think that he's going to be released. But if you think he's going to be released, please tell me in the comments below and state your claim because I want to know. Don't forget to like, share, and subscribe to this video. Until then, be blessed and I'm out. Bye.